Today we have someone very special who is going to be educating us on avoiding disputes in bullion imports. It's an honor to introduce Advocate Kishore Kunal. He is a Supreme Court advocate on record at the Supreme Court of India, specializing in tax and commercial litigation with a strong proficiency in import regulations and compliance. With over a decade of experience representing clients in complex tax and regulatory environments, he has become a recognized expert in resolving issues related to bullion imports, which is a very critical area for India in trading and financial sectors. Mr. Kishore Kunal has a very practical approach. While he strictly adheres to the changing governmental guidelines, he also keeps it malleable enough for people to understand that what is the best approach possible for them. A frequent speaker and a contributor to many expert legal forums, he has advised major importers, companies and trade associations on the best import practices. Also, drawing from extensive courtroom advocacy and advisory roles, he is known for demystifying complex statutes, providing actionable compliance strategies, and being at the forefront of shaping best practices in the field. Ladies and gentlemen, let's give a resounding round of applause to our first speaker of the conference. Let's hear it for Mr. Kishore Kunal.
Good afternoon, everyone. By way of introduction, my name is Kishore Kunal, and as the presenter also pointed out, I am advocate on record before the Supreme Court and regularly practicing tax and white-collar crime-related matters. Today, as luck would have had it, we are at a situation where we are trying to explain to everyone here as to how to minimize any sort of tax dispute which arises in bullion specifically. And as luck would have had it, I just spent, in fact, 6 hours yesterday trying to explain to a tribunal in Hyderabad as to what is the real difference between when you import something which is just shaped as a pendant compared to a situation where it is imported and the customs department feels that it is something which is in the nature of a semi-finished article. Now, for all you guys sitting here, of course, that's a situation which is very basic, which is very simple. And any person who has actually dealt with bullion ever in his life will understand that there is a remarkable difference between what is semi-manufactured versus what is sold in the market as pendant. But imagine a situation for me that we actually rushed through the entire hearing just to explain this simple situation to the judge that, no, what I have imported is actually something which is commercially available, and therefore it is something which is always in a finished condition. You should never consider this as an unwrought or a semi-finished article which is not arrived at the stage of even being close to a finished article or a pendant. Now that's the situation which we are trying to explain in the presentation which I'm going to proceed with. But largely, this presentation I would have ideally wanted a little more a more bilateral than a unilateral conversation, where I'm just presenting what I have in my mind, whereas I cannot really understand or speak to you specifically about your issues. We'll keep that towards the end when we have the entire question and answer series. But just as a matter of introduction, and I'm sure that all of you are aware of this, there is a growth in the bullion industry, and I need not labor on this much because this is something which all of you sitting here is aware. There is a gradual increase, or rather a growth in the entire import of bullion in India. But what is remarkable and why we are here today is this. While there are increases, like there is a significant increase in import of gold, look at the situation which is there with respect to the customs dispute. Now, why do these disputes really arise? We are today dealing with a situation where every small import or to a very big import there are frequent pendencies of litigation, especially relating to customs. And look at the numbers. The numbers are alarming. As opposed to the total disputes which were there in FY 18-19 of approximately 25,000, and this is a verified data source from CAG. Today, in 2022, it was approximately 50,000 pending cases. And what is more astonishing is what is here. Please see this and have a close look at the red line. More than undisputed arrears of what is being claimed every day, day in and day out in the newspapers about collection of tax, etc. As recent as in FY 2022, as per the CAG, 80% of that related to a disputed collection of tax, of customs duty. As an importer, when all of us, and having practiced this law for the last 18 years and specifically dealing with bullion industry for the past at least good 10 years or so, I can say it with some certainty that most of these disputes, which is there in the 80% zone, they don't last. They really don't last. We have had situations where an import takes place. There may be a difference of view between us and the tax officer or the appraising officer who exists. Immediately what happens is the goods are stopped. You cannot release the goods. You cannot use it for the purpose that it was imported. And what does it really lead to? It leads to a situation where gold, being such a sensitive market-driven commodity, suffers complete loss, and in fact it becomes a totally different situation for the importer. He had a completely different business in his mind when he was importing the article, and because of issues which were raised at the import level, the situation led to a point where, unfortunately, because of some appraising officer's view, the entire commodity is stuck for weeks together, sometimes months together. Now, what I am pointing out in this slide and what requires some attention is 80% of the collection which is made on a year-to-year basis is of disputed nature, and most of it does not stick. It does not. Either before the first authority, which is the adjudicating authority, it's quite rare that adjudicate, and this is something which is well known. So I am not saying something which is off the cuff or not backed by some data. Most of the tax customs related disputes are confirmed, or basically it's the department's first adjudicating level where the SSC loses his first case. But invariably, none of this travels beyond the tribunal against the SSC, and the tribunal, because of comprising of a judicial member, of a person who understands the law, invariably decides in favor of the importer. So what happens between, and coming back to the example which I was giving you where I started from, the situation which I dealt with yesterday was a situation where the import took place in 2021, and here in 2025, I am still fighting a case which is as simple as explaining someone that, listen, pendant is a finished article. It's as basic as that. And that took 4 years for the department to really understand. Now, whatever may be the outcome of the hearing yesterday, but at least in my mind, at least in the minds of the person who imported it, this is a sheer waste of time. Now, how do we really overcome these kind of situations? And while addressing the suggestions in the later part of my presentation, my focus is going to be how to be someone who is more logical, more business-driven while dealing with the authorities, regulatory authorities. And just for your reference, we are only concentrating in this presentation because it's a huge topic. It's a topic which is never ending. The number of cases that I have dealt with in the bullion industry range from, and I was just talking to the organizer when I walked in, and he mentioned that there is a recent upheaval of entire proposal to include coin in the BIS. I told him, blame me for that, completely blame me for that, because it's something which unfortunately started from an investigation where I was dealing with that matter from the investigation level. We lost at the first level, at the adjudicating authorities level. But today, the tribunal has decided in our favor to say coins which are there in the customs tariff are coins which are legal tender. And so therefore, a non-legal tender coin is something which is an article of gold, and therefore applicable customs tariff heading has to be made applicable. Now, this leads to a situation where the department has not really stopped there, and obviously they have moved to the Supreme Court where we are representing those clients. But effectively, again, a situation which is as basic as what is the difference between a coin and a legal tender was to be explained at breathlessness levels to the department. And finally, some tribunal has decided it in our favor, and all the entire industry has got a lot of relief for this. Where I started from is where I will again come back to now, and I will keep coming back to that same point, which is how do we ensure that litigation is reduced? In this slide, what I am referring to are day-to-day situations. This hits the newspaper on a day-to-day basis. This is all something which is there in the public domain. What happens when you import? And you import with a strategy in mind. You become part of this news, which is the positive news, which is a news where the High Court or the at the level of Supreme Court or wherever, someone has come to your rescue, someone has ensured that the goods that you really imported, that you really required, has reached your hands at the same time and at the place that you required it to. As compared to this, none of us want to be here. And please mark this very clearly. The difference between the earlier slide and this is a strategy in mind, is a clear focus in your mind as to what is the regulatory regime, number one. What is it that is expectation of the people who are actually going to appraise the product that I have imported? And what is it that ultimately will lead to a situation where I can reduce any sort of a tax dispute which can happen? Mind you, 80% of what has been recovered is something which is a disputed tax by the government. However, how do we ensure that we reduce that further and further is by strategies, is by making ourselves better in terms of knowing where we are ultimately going to arrive at. Now, therefore, it leads us to a situation where we see as to what are the kind of disputes which may arise at the level of import, and what do we need to be really clear on at the post-import level. And during the slides, I will also discuss some of the practical issues that we have faced in the recent past, and how do we really overcome those practical issues. And I'm sure most of us here have dealt with tax authorities in different points in time. Now, there are various stages of a tax dispute. At the stage of import itself, if you're aware of this, and unfortunately as big importers, as importers who regularly import, not much is understood of how the actual legal setup in India works. What is it that I need to do to ensure that I get minimum interaction with any investigation at a later date? The entire seed, according to me, is sowed in at the time when you import. But just for your information, the various stages of a tax dispute in India start from, when you import an article or any, commodity. It is there at the customs port for some time. What is required by the appraising officer is something which is either with respect to, is your invoice actually reflecting, or your bill of entry actually reflecting what is there in the container? Is your import documentation aligned to what you have imported? If it is a country of origin related issue, then is there something which can really be helped at that stage to know whether the country of origin is correct or not, so on and so forth. So this is what is happening at the import level. Going forward, if the customs department finds that there is something which is amiss there, or there is something which is untoward there, they move forward and do an investigation. And a lot of us, and I'm sure at least I can say it with some experience in my hand, most of us have heard of DRI, most of us have heard of preventive, Most of us have heard of SIIB. But before they reach there, it is the appraising officer who has the first eye on what you have imported. Are you therefore cognizant of what actually is the appraising officer looking for? What is it that may lead to a situation where there may be a dispute at a later date? Because mind you, what I am remarking towards is the last bullet of this slide, which is at every stage, it is you, your directors, your people who are at the helm of the affairs, they are made to unnecessarily go through a lot of rigmarole if a DRI or a SIIB or a preventive steps into a conversation and tries to investigate something which, as reminding you, is 80% of the entire lot. That's why, just briefly taking you through what kind of disputes can really arise at the import stage. It can be classification, it can be related to any change of import policy, any origin-related dispute, or any restriction which may have been imposed in import of goods, etc. Now, all of us have seen this. I'm sure I'm talking to a crowd which knows more than me, at least in this, and whatever knowledge I have today is all because of the learned clients of mine. And gold is one industry where every client that I have met, 100% knows more than me, 100%. So I will not labor too much on the different parts which are there in Chapter 71, which is the HSN chapter which deals with customs classification. But what is of relevance for us for today's discussion is, have a closer look at where do you really belong. There are 18 subheadings which are there in that entire chapter. Each of those subheadings, and when I say subheadings, we are talking about 4-digit classification, etc. In customs law, there is basically a 2-digit, which is Chapter 71, a 4-digit, which is 7101 till 7118, and then there is 6 and 8-digit. That is the granular specific detail of 8-digit classification which the appraising officer is going to look at. So if your supplier has put a particular HS code on your invoice, is that what is available in the container? That's the question to be asked. And as some learned person has told me quite early in my career, always ask, what is this? Why is this? Who gave you this? Where did it come from? These are basic questions. If on an import document, and let's step a little behind that, from the purchase order stage till the actual import, at every stage, you need to bear in mind that there are 18 subheadings, out of which that 8-digit level, there are further subheadings. So therefore, you need to be aware of what is there in the container versus what the supplier or in your purchase order you have quoted as a HS code. And that's a super important question. Now, customs classification, now what I was dealing with yesterday, for instance, is a situation where the product was in the last category, which is a jewelry, it's a pendant, therefore it's a jewelry. The department said, no, sorry, because of the weight or because of the purity, etc., this is something which should have been earlier. Now, similarly, we deal with a lot of situations, and it's a matter of, again, public source, and the case which I did also is a matter of public source. There are a lot of disputes which happen because something has an alloy, something, and going back to the slide where we were dealing with a situation relating to this, preferential duty treatment and the detention by the department. And why did it really happen is because of the situation that we are dealing with right now, which is the classification at the 4 or 8-digit level. It's that important a situation where a preferential rate of duty or a FTA benefit can actually be denied if your classification is not in tandem with what is declared. So an alloy, whether it is an alloy, whether it is a strip or not a strip, whether it is finished or it is unwrought, whether it is, I'm sorry, I'm basically just repeating what you guys already know, But just for my own clarity, all of us are aware that there are various stages in which gold is actually reaches the customer. There is, ore leading to doré, leading to further refinement, leading to further jewelry, and then finally leading to something which someone may make a lesser purity jewelry or whatever may be the situation. Mind you, each of these different categories can be classified elsewhere. So therefore, what should be your strategy to avoid a dispute? Now, all of us are very sensitive about our data. All of us are very sensitive about our business strategies. But effectively, where do we lead to? These are the methods which you can use to actually avoid that so-called dispute which may arise. Now, there are situations where we are planning to import, or there are several situations where, there are strategies in place, etc. Advanced ruling provisions of the customs law are very, very important. Why are they important? If you are already in know of a situation that I am going to import, I am someone who is going to import in bulk, and I am someone who is going to regularly import it, if your advisor says that, look, boss, there seems to be some issue here. Now, go back and remember the second slide. Do you want to be in the first slide or the second slide? That was the question I posed you. The first slide deals with a situation where within 3 months, you can actually get a customs classification dispute ruling, compared to a situation where you can fight endlessly and be one of those people who has fought for 4 years, 5 years, trying to explain the difference between A and B. Therefore, please use this to your advantage. The law, if you know, is your friend. If you don't, it's your enemy. Try and understand it from a business point of view. While, as I said, there may be situations where the business strategy is quite sensitive, and therefore you don't want to be one of those people who are going to just imitate someone, or someone imitates your business decision. But let's understand, all of them do it ultimately. One person importing, the other one will also import. No longer is a situation where someone importing a particular commodity, stays a secret. And I'm also cognizant of the fact that gold is a market-sensitive commodity, and therefore it's something which effectively needs to be cleared at an early level. All I am requesting, therefore, to avoid a dispute is be a little more cognizant of what is going to follow. And not in all cases do you need to go to a classification dispute where there is an advanced ruling situation. You can always ask your advisor, is this something which is really that contentious? And therefore, should it lead to a situation that it needs to go to advanced ruling? That's the point that I'm making. Similarly, restriction-wise, all of us are aware that there are certain restrictions which exist, which don't exist, etc. The foreign trade policy provides for a classification, for a clarification from the DGFT. Now, let's understand what kind of disputes arise on a day-to-day basis that we have dealt with. Every time there is a change in tax rate, here we are dealing with a situation where my goods have actually arrived and I have filed the bill of entry and the rate has changed. What do I do? Find out the date of assessment. And here, mind you, there is a minor difference. The difference is your date of presentation valid, which is, as I was mentioning, any appraising officer you have specifically dealt with has actually, you have filed your advance bill of entry. Is this something which will apply as on the date of presentation to him, or is it something which will eventually apply on the date that the goods are cleared? Now, that's a situation which has already been dealt with, and there are several cases that we have effectively dealt with here, where the date of presentation to the customs officer is held to be the relevant date. And therefore, when you present the bill of entry, irrespective of the actual assessment date, becomes the relevant date for the purpose of assessing or for the purpose of knowing which rate of duty will apply. Similarly, now let's deal with import policy. Import policy is something which frequently changes. Today something is restricted, yesterday it was not restricted, tomorrow it will not be restricted again. It is the date of shipment dispatch from the port that you actually exported from is the relevant date under Indian law. And this also we dealt with I was party to one of the matters which traveled up to the Supreme Court, where the change was effected, but the court eventually held that it is the date of shipment which is relevant. It is not the date of assessment or date of presentation of bill of entry that will become relevant. Now, similarly, there are situations, and what it really effectively leads us to is, if there is a change of import duty, there will always be either a refund or there will be an exceptional or additional payment of duty. Similarly, in the case of import policy, whether there will be a confiscation or not is something which is determined based on if there is a restriction which is available or not. Now, what is the solution ultimately? And a lot of us have this pain point. My goods are stuck. The law has recently changed. How do I deal with it? The way you deal with it is there in the law, which is one of the methods which are provided here. Any of these methods can be taken. Now, I wanted to spend some time on this, but I will quickly rush through this so that we come back to it if it is required. The manner in which this effectively works now, as we speak in September 2025, is different than what was there earlier prior to March 2025. What has changed? What has changed effectively is, earlier, when you did a provisional assessment, and a lot of us are aware of this terminology, I'm taking the leap of faith that all of us have imported at some point in time, and that's why I'm here and that's why I'm talking to you. A lot of us have undertaken a provisional assessment. Earlier, till 2018, there was no time period for the Customs Department to actually finalize that assessment. What did it lead to? I dealt with a case where in 2015, there was a bank guarantee of some 25-30 lakhs which were given, and till 2024, that bank guarantee was never returned. It's 8 years. 8 good years of bank guarantee money which is stuck. What is it then the court effectively laid down? They said that if there is no period which is prescribed, you have to go by a reasonable period. And in that case, it is one of the peculiar cases where bank guarantee was directed to be released along with interest. Unheard of. And it's one of the cases which stands on a very different footing. But if there is a delay, you can always approach court and ask for interest. If the Customs Department is asking for interest for a situation which never arose, and that 80% is the disputed area, that 80% they better pay interest on. So never lose your right just because there has been a dispute. Now, effective 2018, this no period was changed to 6 months. So provisional assessment needs to be finalized within 6 months. Now, what has happened now and why we are talking about it is because now that period has been increased to 2 years. So I import something today, I undertake a provisional assessment, I discharge a bank guarantee, which we will come to that. A lot of it is completely unreasonable demand of 100% bank guarantee, 150% bank guarantee, deposit the interest, penalty, everything at the stage of import. And because I need the goods, I get it released on that bank guarantee. Effectively, I get to see that bank guarantee release 2 years hence. Now, that's a situation which was never contemplated by me when I imported. There are similar such situations even with respect to import policy, where if my goods have been seized because of there being a restriction, etc., I can always re-export it. The law provides for it. Are those rights being exercised? That's the question to be asked after this session, which all of us can deal with. Now, some interesting legal positions which have arisen because of these changes which have been made are, this 2025, now they have put an amendment to say that 2 years should be the date which should be made applicable. There's a new provision which has been inserted. Is this something which will apply to me? I imported in 2015. Will it apply to me? Now that's a question which is still to be deliberated, which we are still deliberating. The courts are, sooner or later they will be seized of it. But that's something which is catching attention. Now similarly, Suppose at the time of import, I did not know about the change of duty, and what can I do about it? Now, earlier, the Customs Department used to hold a view that, sorry, you cannot amend what you have filed unless it's an inadvertent or a mistake which is just apparent on record. Courts have intervened, said no, not just that. If you have not claimed a benefit, for example, I imported something. There was a benefit which was available to the goods. We have seen a lot of commodities which are there in general exemption. I did not claim that exemption. I can always go back if my advisor says that applicability of that exemption is available. I can always claim it at a later date. Why not? It's a right. It is available. That's something which is to be cognizant of. What is also to be cognizant of is the most debated topic, according to me, which is country of origin. And what is important there is country of origin as a matter of principle. Till very recently, there were a lot of foreign trade, free trade agreements which India entered into. A lot of it went into dispute at the bullion import level, because what was given by one hand was trying to be taken away from the other. And courts there have dealt with a situation where courts earlier intervened and said, no, once a foreign country has issued a country of origin certificate, you cannot dispute it. Now, what did the government do to get over that or basically mitigate their risks is this, which is instead of country of origin certificate, now it requires a proof of origin, not just a country of origin. And mind you, this is all done at the level of Indian law, not in the FTA. FTA continues to say that if you have a country of origin certificate, that's your unimpeachable evidence of what is being imported, and therefore the origin. Now, there are these compliances which we have just listed out for you guys to have a look at even at a later date. The presentation will be available. But one needs to therefore deeply deliberate on what kind of commodities are being imported. Are we aware of what the appraising officer is going to ask? And are we aware of what effectively will lead to an investigation? And that is where I think all of us need to be clear on, what kind of documentation should we ensure, etc. And if we do not do those compliances, what do we ultimately lead to? We lead to a situation where the preferential treatment which is being given is withdrawn midway, and therefore what I had imported, thinking that I will have some margin while importing the goods, I lose that margin. So that one step which one needs to take at the stage of import is a crucial step to avoid any sort of a dispute. Because mind you, the judicial view on this recently has been that the Customs Act prevails over the FTA. Now, that's the High Court, and that issue is still pending before the Supreme Court, and we are dealing with some of those issues. But effectively, what it leads to is that don't be so sure of your country of origin certificate alone. Look at the Customs Act, look at what the law requires you to maintain that, only to ensure that you don't land up in a situation where the only margin that you had was the preferential treatment, and that's gone. That's the point to be deliberated in today's discussion. And these are some of the suggestions which I have, which is basically maintain contemporaneous documentation. All of you are aware of Carotar. Maintain, prompt responses to all the queries that are being raised, etc. And basically, that's the situation that we need to be clear of. There is a larger part of the presentation which dealt with the situation of investigation, etc., etc. With the time constraints that I have, I'll stop short right here. Yes, please.
This question may be very generic to all the people, but would like to understand. When we generally do an import on FTA cases, and when we clear the goods on bank guarantee, most of the times it becomes a big nuisance to claim back the bank guarantee, and even after a year, we don't get response, whatever the mails we send to the origin country, or the FTA cell here, or the customs commissioners here in the port of clearing. How do we take it forward? It can be a general question which can give answers to many of our questions where we can take it up in the future.
In fact, a very, very important question. And let me take this, divide it in two parts. If you have today, as we speak in September 2025, any import prior to March 2025, then there is no specific prescription which was there earlier, but the law now requires that they have to necessarily return it within 2 years, and now that 2 years will commence from March 2025. Now, one way is that you accept it and move on, that you wait till 2027 for that FTA, which the FTA promised 6 months of verification, whereas now you're sitting for the past 4 years and nothing has happened. While every case will have to be looked at separately and one can approach court to get that bank guarantee, one very important aspect I must point out is a situation where I personally have dealt with that, where what you just mentioned happened. Calcutta Customs said, sorry, go to DRI. They had issued an alert and therefore we cannot return it. DRI wrote back to the Calcutta saying, I don't know, the FTA cell is actually looking at it. Effectively, for a good 5-6 years, the importer kept running from one place to the other. And effectively, the court stepped in and said, no, sorry, return it. Because when the import was made, the law was that within a reasonable time, which is 3 months to 6 months, you have to return the bank guarantee. Since you have not, therefore pay interest from 2015 till 2023 in that case. So that's where we are.
So, I mean, can we take your answer as, like, for example, whoever have been struggling for past 6 months or 1 year or 2 years, can it be taken as assurance that if we wait for 2 more years, that will automatically come back to us?
I mean, there's no such surety even then, but you'll have to approach the court. What you can certainly do to mitigate any risk later is start writing letters. Ask for your bank guarantee back. If nothing is working out, approach court. If you're not getting any response, approach court. And mind you, these kind of situations, and I understand that a lot of times bank guarantees are, of a certain amount, and you don't want to end up into litigation, which is far, more expensive. There are situations like that where you can actually make that documentation and ensure that at least you get that interest, so that at least your litigation cost is out.
No, I understand, but I mean, as you rightly pointed out now, the bank guarantees can be as low as less than ₹1,00,000 and this can be as high as multiple crores of rupees.
Yes.
But for a person where few lakhs or less than lakh is stuck for over a period of time, he will definitely not want to go back to the court and spend. And if it is one such importer, many such importers put together, it's going to be definitely a huge amount of money, which is going to be unaccounted and unclaimed, lying somewhere because of anybody's lethargy in their functioning.
Absolutely. And so therefore, it's a situation where now effectively the law provides 2 years. So they will have to necessarily do something in the next 2 years unless that time is extended. So 2 years you can take it as the time from today. So unless, as I said, you move to court, and if the amounts are that heavy, and that you can move to court.
So it's sort of wait and watch.
Yes, wait and watch for 2 years. Now the law has at least provided for it. Earlier the law didn't provide for it. So it was a more opaque situation earlier. Now you have a 2-year window which is available.
Thank you.
Thank you, and thank you so much, Mr. Kishore Kunal, sir. A round of applause, please.